Okay. I want to watch this. I've already shared it out, but the importance of the arguments that are made in this case cannot be overstated. This is this is probably this, in my opinion, obviously, um, one of the most important debates to have right now related to the elections. It does not get more vital than these arguments that I'm about to share. This is from the YouTube page of a guy named Robert Gouvet, I think is his name, Robert Gouvet Esquire. Go sub to him. I shared it out on my Telegram so that we can all follow along with this case. Very, very important. Okay.
The elections clause, very important clause, governs the
Excuse me.
elections.
Sorry.
We spent a lot of time talking about what it
I have
means,
this new
how it works.
headset, so if you'll have a problem with my audio, okay, leave your complaints and constructive criticism in the comments below. um, I don't, I don't know. This is supposed to be good. It's some gamer something. See, look, it lights up. There's snakes. I don't know. It matches my perfume bottle, my new perfume that I just got as a gift. It's one of my favorites. Anywho, they match. Look, whatever. Um, Seriously, I apologize for any audio glitches, okay? Because I don't know. But this should hopefully be better audio than what was on my cell phone before, whenever I was talking about the Secretary of State, which will be covered in this. We'll get there.
Works, who has control over the elections. It's pretty well detailed in the Constitution, but there are a lot of ways to interpret it. And so we're going to talk about
I
that today.
suppose.
First, let's look at the actual text. You see it here, Article 1, Section 4, Clause 1. It says, the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Right? That's the legislature. But, you hate those buts. But the Congress may at any time by law make or alter such regulations, except as to the place is of choosing senators.
And there's a reason that that's at the top of all of my reports. That's at the top of all of my poll watcher trainings because this is one of the most important aspects to understand when you start getting into investigating your state and county's elections. Okay, you have got to understand who's who's supposed to be in charge as opposed to who is in charge, which you'll find out when you start to conduct your own investigations. This cannot be more vital to what's happening to our elections right now in this country. Super, super important. We've got to nip this shit right in the fucking bud. Pardon my French.
Interesting phrase. The subject of a lot of litigation. Now, we talked a lot about this. One of the main critiques of this, right, one of the main issues that
Basically, what this says is it's the states' rights, right? It's the legislature of each state. It's their duty to make or amend election laws, procedures, and everything. There's nobody else that's allocated that authority. Okay, not nobody else. There's no other entity at the state level, but the federal government, this federal legislature, is allowed to issue regulations. An example of that would be the Help America Vote Act. That they can say, hey, I want you guys using paper ballots. I want you guys using actual ballots. I don't want y'all I don't want half the states, you know, using paper ballots and the other half the states are throwing noodles at the fridge and whatever sticks, that's who wins. No, you're all using paper ballots now. That's the federal legislature has the authority to regulate certain aspects of it, right? Now, the Help America Vote Act is really sort of like financial incentive to adopt the computerized voting systems. That's kind of what that was because the federal government is limited in what it can regulate. Like it can't force all of the states to adopt a computerized voting system, but it can incentivize it financially, and it has.
saw related to this was that a bunch of elections had the rules changed by the state courts, by the state secretary of states. They would file a lawsuit. The courts would then maneuver things around. or somebody would just waive a rule, right? A governor would do something and maneuver the rules around. But guess what? The judges are not Congress, okay? The judges who are changing the rules because of these emergency provisions, they're not Congress, are they? No. And neither are the secretaries of state. So they're not making any regulations. How are they altering regulations? How can they do that? They can't. The only people, right, according to this theory, they can actually adjust the time, place, manner, the manner of holding elections, the time where the vote takes place, the location, all of that stuff is the legislature, right? The Secretary of State can't just decide that COVID is very scary, and so suddenly we need a bunch of ballot boxes all over the place. She's not the legislature. She's in the executive branch.
Yeah.
So it's seemingly,
Yeah.
it feels pretty obvious to me. Now, we spent a lot of time talking.
It is obvious. I mean, it's plain as day. If you have a copy of the Constitution, it's Article 1, Section 4. This is really good. You should read it. It's right in there. It's pretty clear. You're going to hear some funky arguments about
this. And
some good
all
ones
of the
too.
courts sort of laughed it out because there is really, limited basis for the courts interfering in elections after the fact. They're okay doing it before the fact, but not after the fact. Anyways, that's the point of, that's the Constitution. That's where it comes from. Now let's dive in to the specific case. We're going to go to the SCOTUS blog and listen to our friend Amy Howe, who drafted a summation of this case. She says, in a high-stakes election case, justices will decide the validity of the independent state legislature theory, right? In other words, that is the provision saying that the state legislature right here is the only body that can actually make adjustments to the laws.
Right.
Amy Howe says the following. The Supreme Court will hear oral argument on Wednesday in a case that UCLA law professor Richard Hasson has called the 800-pound gorilla of election law. Yeah, we covered a lot of this back then. I was very upset that the courts were manipulating the rules because of my COVID. The case is called Moore versus Harper. We're going to listen to oral arguments on it in a minute. It's a test of the independent state legislature theory, the idea that the Constitution gives state legislatures nearly unfettered authority to regulate federal elections with little to no interference from state courts because they're not listed in there. They're not on there. Depending on whether the justices agree with the theory and how broadly they interpret it, it has the potential to upend federal elections by eliminating virtually all oversight of those elections by state courts. Meaning they can't just change the rules willy-nilly however they want. There's two provisions that this comes from. We just read both of them. Proponents of the theory argue that under the plain text of those two clauses, just plainly reading them, as we just did, state courts are not authorized to supervise how the state legislatures run elections for Congress or the president. Critics argue that neither clause was ever understood, including at the time of the founding, to confer such unchecked authority on state legislatures, right? So we're going to hear from only one side today, which is the people who are bringing this challenge, the people who are advocating for the independent state legislature theory, because the justices actually, kind of articulate the opposing arguments against them. So we'll let the judges do it. Supreme Court, they say, has never endorsed this theory, but it did make an appearance in Bush versus Gore. Antonin Scalia and Clarence Thomas set out that his view that the state court's recount conflicted with the deadlines set by the state legislature and thus violated the state legislature's authority under Article 2 Electors Clause. Absolutely right. 100% right. Because it's ridiculous. If the court can just change and just modify the election however they want to, then the Constitution has no meaning.
Yeah.
Because it doesn't say that they have that authority.
It's like, well, just fuck us then, right? Fuck us and everything we believe in. I mean, it says what it says, but that doesn't matter, actually. I mean, it actually means something else. Something that it doesn't say is what it is. What
at all in this plain text. But what the Biden administration and what the lefties will argue is that, oh, no, 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 no. If you really expand the scope and if you listen to what their founders and what their brothers and sisters, who came over from England said 300 years before them, then it'll all make sense, right? Then we can consider it to be, yes. In other words, they're saying that this definition also includes the courts and it also includes the executive. But obviously it doesn't. Let's listen to Judge Clarence Thomas ask for some foundation. David Thompson argues for attorney Thomas.
Let's listen
Moore.
to Clarence Thomas. He's
I'm
my
sorry.
favorite. That's my boy right there.
Thomas More is the foundation. David Thompson, attorney for the Thomas More Foundation, is asked by Judge Clarence Thomas for a little bit of foundation. He says, Mr. Attorney, why are we here today? Can you tell us what we're doing?
Counsel,
A fair
this
question.
case is from a state Supreme Court that interpreted and applied a state constitution. So it would be helpful if you would take some time to explain what exactly we are reviewing, what decision we're reviewing, and what is the basis of our jurisdiction.
Yes, Your Honor. Thank you.
Original.
So the court is reviewing the decision. There was an order on February 4th of the North Carolina Supreme Court, and it was accompanied 10 days later by a written opinion. And in that written opinion, there was a liability determination that the elections clause did not apply. And importantly, there was also a remedial determination. And we can see this at Petition Appendix 142, where it empowered the North Carolina Supreme Court, empowered the lower state court to draw the maps if necessary. And so that is a final order of the North Carolina Supreme Court.
Okay, so two things, right? One, it's sort of a declaration that the election clause doesn't apply. So it doesn't really matter what the underlying litigation is. Somebody sued somebody. They said, well, you can't do what you did, court. You can't do this. The elections clause is like, it says that you don't have that power. Only the legislature does. So why are you doing that? And the court said, well, the elections clause doesn't even apply. And so he's saying that's obviously insane. That's why we're here, because some other court, a state court, Clarence Thomas says, why are we here? It's a state court. It's a state issue. We're the federal Supreme Court. Why do we even accept this case? And he says, well, because they're violating the Constitution. They're violating all of these rights, right? The elections clause is a very important clause.
Mm-hmm.
Other thing he says is it's not just a declaration that it doesn't apply. Like that we're not just here because they said something. We're also here because the court gave another court power to do gerrymandering, right? To create the congressional district
Right, that
lines
they don't
and
have.
other things that are delegated, powers delegated to how elections are run, time, place, and manner of the elections. All of that is legislative power, not the courts. That's why we're here, Judge.
So it's a
And
violation
it passed
of
on the relevant
Constitution.
questions. In addition, there's
In
a
violation
second
of
final order,
state
which is on
legislatures'
February 23rd. There
authority
was a denial of a stay
granted by the state
application,
constitution.
and that too is a final order of this court.
We don't normally review state Supreme Courts interpretations of state constitutions. So what I'm looking for is why, for example, if this were a case about a state legislator or a legislative district, it'd be doubtful that you'd be here under the state constitution. So I'm looking for an explanation as to why this case is here and what's the jurisdiction for this case. How does it differ from a purely state case?
Well, Your Honor, our position on the merits is to take as given state law as interpreted by the North Carolina Supreme Court. We're not asking this court to second guess or reassess. We say take the North Carolina Supreme Court's decision on face value and as fairly reflecting North Carolina law. And when one does that, we see that there's a violation of the elections clause. And that's why we're here.
It's a federal issue because it's violating your elections clause, and we need your help on this. Okay, so hopefully that lays some foundation, right? This is about state elections. We have issues with a court that is saying the elections clause doesn't apply, and that the court has power to make changes to the elections. And the complaint is saying, no, you don't. It's not here. Article 1, Section 4, Clause 1. It doesn't say court in there anywhere, right? All of that is
Right, it's just the state legislature and then the federal legislature, right? The concept of the legislature, right, which would be the legislative branch. Just so we're clear, we have to be on the same page about these arguments. It's so, so, so important. This is the basis for most of what we're finding, okay? I cannot overstate the importance of these
preserved to a different
arguments.
section of the Constitution. The court doesn't have the power to do that stuff. So we have the attorney. He continues on, and we're only going to be listening to him today. The government, of course, made their opposing arguments, but he gets pretty much beat up by all of the attorneys here today. David Thompson is questioned by Chief Justice John Roberts about the history of election law.
You concede that state legislative action under the Elections Clause is subject to the governor's veto, right?
Yes, Your Honor.
Well, the governor's not part of the legislature. Why do you concede that point?
Well, Your Honor, first of all, we're not here to relitigate Smiley. We're prepared to accept all the court's precedents, number one. Number two, I think the Arizona dissent pointed out that Samuel Johnson defined legislature by reference to Matthew Hale's definition, where he said the three branches of the legislature, the two houses of parliament, and the king, because it was understood at the time of the founding New York and Massachusetts had gubernatorial vetoes. So it was understood that the governor had a role to play at the time of the founding, and at least it's arguably grounded in the text.
So the Chief Justice is asking him about this. He says, wait a minute here. You're saying that it's only the state legislature that has power. Okay, if that's what the Elections Clause says to do this stuff. Oh, but then why do governors have the veto power? Because if they have some say over the elections, right? If they can say, nope, vetoed, the whole thing's gone, the whole thing's vetoed. Well, then doesn't that mean that the state doesn't have all the power in the world, right? So we sort of allow that to happen, right? The governors can do that. It sort of exists in the law as it stands. So in other words, what's the difference between
This is a good.
a governor in getting involved or a court getting involved?
His response
It
is
seems
really
like we
good.
allow governors to get involved. There's a lot of
Important to
precedent for that,
understand.
right?
Well, given Smiley, if your concession doesn't undermine your position, doesn't Smiley? I mean, that's a pretty significant exception. You have otherwise a very categorical case, and it's sort of well with this one exception, but vesting the power to veto the actions of the legislature significantly undermines the argument that it can do whatever it wants.
Well, Your Honor, that's a procedural limitation. And as we understood Smiley, it was talking about defining the legislative power. And here we have a separate issue. We have trying to limit that legislative power. So however the legislative power is defined under Arizona, under Smiley, we are not, we can take those precedents as given, but what can't happen is there can't be a substantive limitation.
Well,
placed on that power.
So you can take the state power all the way up to a certain point. They can manage time, manner, place, location, all of that stuff. But because we live in a system of, or used to, whatever, live in a system of government that has checks and balances, right? The governor has some veto power. And so the state legislature can exercise their power all the way to a maximum level until they get capped by the governor. That he says that's okay. That's just a procedural limitation. Okay, that's all perfect. Checks and balances are good. The problem here is the substantive limitations. It's when now you're going to the nuts and bolts of what the legislature is doing. It's when you're saying that no, actually, the court can do your job, right? The legislature decides what the districts look
Right.
like. That's the manner of the election.
Right.
But if the court does that, that's not a procedural limitation. That's not just saying, oh, we're checking your power. No, you can't do that. Or
Straight
I have
up.
some sort of mechanical response. No, it's the opposite. It's saying we're doing that now, right? We're just going to take that over and we're just going to draw the districts ourselves. And we're just going to move the deadlines ourselves because we're the judges and due process and equal protection and equality and equity and whatever. COVID. He's saying, no, that's not right at all. The governor is the procedural. What the courts are doing in this case, Judge, is the substantive. So he's making a distinguishment.
And last question, at least for a while. Why do you say it's procedural. Let's say the governor
Why do you
is
say that?
opposed to the legislative action with respect to the elections, then that the legislature endorses. He's the opposite political party, has a whole different view, and says, gives a speech saying, it's wrong because of this, not because of procedure. That strikes me as saying, they're supposed to have, 2 votes on it or whatever, and they didn't, or, they need a committee report. That sort of thing is procedure. Straight out veto, we really don't know what it is.
We're
So he's saying that, yes, the procedural veto could very much be substantive, right?
I mean,
Which is true.
yeah, but
A governor could exercise a procedural veto because they didn't like the substantive outcome.
proposing a formalistic test for procedural, which is it a step, a hoop that needs to be jumped through? And if presentment is one of the hoops that the state legislature needs to jump through, then under a formalistic approach that we're suggesting, then that would be procedural, Your Honor.
Oh, sorry.
That was
Please.
Amy Coney Barrett jumping in there. But that is Chief Justice Roberts asking about the governor's veto. Very interesting line of questioning. How do you separate this? Right? We've got the 3 branches. They're co-equal. They have checks and balances to make sure that nobody gets a little bit too out of control. And they're supposed to push each other back. The legislature,
Yeah.
Congress, should not be delegating all of this authority to the president. That's insane for them to do that, but they do it
Okay.
because they're scared little children.
Yep.
And they'd rather not
or
have
the
any
SOS
responsibility.
or
But the
a
point
judge.
is, right, these are institutions that should maintain their power, claw for it back. So if a legislature is having its power usurped by some judge somewhere or some secretary of state somewhere,
Mhm.
they should be clawing that back. That's ours. We tell you where time, manner, and
Exactly. That is their job to do. All right. So I don't know when the Texas state legislature is going to pick their balls up off the floor, or if, Keith Ingram has them all in a jar, in a schifferobe in his office down in Austin somewhere, but they need to take their authority back. They got to take it back. They don't actually, this is where we're at. So these globalists know what they're doing. Well, they're just not that smart. We also know what they're doing. The legislature has the authority to make election laws, to make or amend, election laws. So when they want to, when a globalist gets into the legislature and they want to say, you know what, I don't think that we can get this codified into law, but you know what, we could get codified into law, that the Secretary of State can establish guidelines for how to use these electronic voting systems. We'll just defer all of that, the guidelines as to how we're going to use these electronic voting systems, to the Secretary of State. And in Texas, the Secretary of State is an unelected position, right? So they're pretty much giving all of their power over to an unelected individual. Okay. And our Secretaries of State are appointed, they're total figureheads. The guy running the show is Keith Ingram, and he's been running the show for over 10 years. All right. Does the legislature have the authority to defer their power? Can the state decide that can the legislature decide that they do have that authority? We can defer all of our power related to creating and amending election laws to an unelected individual. We just give it to them. Do they really have that authority? I mean, the national constitution says that it's the state legislature's job. Let me put it to you. Let me phrase it this way. If it's my job, right? Somebody hired me to do a job, and they're paying me to do the job, right? And someone else has another job, and their job is to sort of assist me, right? Do I have the ability to give that other person all the responsibilities and duties of my job, right? I could say, hey, yeah, it's my job to type up this report. It's my job to get this out by the deadline. But you know what I'm going to do? I'm going to decide that this person can help me. All right. They can assist with that. Here you go. They're helping me. They're assisting. Like, do they really have the authority or the ability to give up that authority? Can they give that authority up that's allocated to them by the national constitution? And if so, why are they running for office? Why are they running and swearing an oath to this constitution when they don't intend to uphold it? You see the severity of the enormity of the situation that we're in. It's bad. So we've got to straight up call out the legislature for being the pussies that they are and giving away their power to a Soros-backed or otherwise globalist and power-hungry individual. Whether they're elected or appointed, they can't be doing that. They really can't be doing that. So that's why these arguments are so important, okay? Because almost every issue that we're finding was authorized by the SOS. Every now and then you get these idiots in the state legislature. They think, oh, you know what? Wait, I've got an idea. Let's pass an election law. But then it's garbage. Then it's garbage, okay? Like SB 1 in Texas. Garbage.
In place are. Why? The Constitution says it. And if you don't like that, then you've got to
So get back to doing your job and do a better job. That's what we need to tell them to do. First of all, they need to get back to doing their job. Then we can address the type of job that they're doing, right? Then we can assess their performance. But when they're not even doing their job because they deferred their job to Keith Ingram, nah.
amend the Constitution. I don't know what else
Nah.
to tell you. That's how this country is supposed to work. Now, this individual, the gentleman arguing on behalf of the independent state legislature theory, now gets some questions from the left. We have Ketanji Brown Jackson,
You gotta brace
who
yourself.
starts us off, and we have Judge Sotomayor, who makes her way in as well. Ketanji is asking about the definition of a legislature. Remember, Ketanji, she had a difficult time defining a woman. Now she's going to have a difficult time defining a legislature.
See this with state courts.
She gonna learn today.
But
State
can I ask
courts-
you a question?
Please,
Can I ask you
do.
a question? Because you suggest that there's this thing called the legislature that the framers were familiar with. And I'm trying to understand why what counts as the legislature isn't a creature of state constitutional law.
Well, Your Honor, I think this court in Arizona did say that the states have a lot of flexibility in terms of defining what state legislature means. But what Arizona did not say is that there could be substantive limitations.
But I don't understand how that's a different thing.
Let me put it to you this way. It actually doesn't. Okay. They can define, I suppose, what the state legislature is, but do you think, Judge, that that the state constitution can decide that the legislature, the judicial branch, and the executive branch are the same entity, one and the same, no checks and balances? Is that the position that you're taking? Is that the three branches of government can be codified out of existence? I just want to know if that's what she's saying.
In other words,
want to know
if
if
the
that's the point
state
that she's making.
constitution tells us
Like
what
gender.
the state legislature is and what it can do and who gets on it and what the scope of legislative authority is, then when the state Supreme Court is reviewing the actions of an entity that calls itself the legislature, why isn't it just looking to the state constitution and doing exactly the kind of thing you say when you admitted that this is really about what authority the legislature has? In other words, the authority comes from the state constitution, doesn't it?
No, Your Honor, it's a federal function, and we know that from Lesser. So this court in Lesser held it's a federal function. When these duties are assigned to the states, that is a duty that is assigned by the federal.
Yes, it's a duty.
Do you see what's happening here? He's giving her some corrections. She says, well, isn't it true? I mean, it's the states. Like, if the states are the people who decide what the legislature is, right? Can't they just decide? So can't a state legislature just decide that we're going to have the governor move the dates, is what she's trying to ask? Or can't we just have the Secretary of State be delegated that power by the legislature, or the judges can do it
No.
too? They can say, a state can say our legislature is really all three branches. And so we all work together on elections, right? That way they can manipulate it however they want to.
Right.
And Mr. Thompson is saying, Ketanji, no, this is not
I'm going to answer your question as succinctly as I can. No.
up to the states. It's in the federal constitution. It's in the elections clause in the United States
It's
Constitution.
a ridiculous
This
question.
is
It's a ridiculous
something that is
position to
delegated
take.
from the Constitution to the states.
That she
It
doesn't.
says in the elections clause, hey, state legislatures, time, manner, place, that's your business.
And the fact that she doesn't understand how to define a legislature. This we shouldn't be surprised, and in fact, I'm not. I'm amused at this point. I mean, you kind of can't write this stuff. You know what I'm saying? Like, if you wrote this, nobody would believe that it's a plausible storyline, because surely nobody would make an argument that fucking basic. Nobody would make an argument that backwards. Okay. Surely. Right. Yep. Here we are.
So states don't have the power to say, no, it's not. Is his argument. He's saying, no, we can't defer
No.
that and say, well, we're just going to go beneath that standard and let whoever they want, run the election however they want. No, because that would be a violation of the Constitution.
Duty is to make this legislative determination, that is, the determination about elections. My question is, where does the entity's power come from to make any determinations at all, right? I mean, yeah,
I can answer that in two ways, right? One, Article 1, Section 4 of the National Constitution, as we've reviewed multiple times. Two, the electorate, who puts the individuals in there to start making these decisions, whether there's going to be a decision made or not. So, but initially, to answer your question, that structure comes from the founding fathers, who used the term legislature because they knew what it means. They know what they can define a legislature. I don't think they have any issues with that. They could define what a woman is too easily.
yes, I see that the federal constitution is giving them the right to make a particular determination, but they're not giving.
Here's the thing. A fundamental misunderstanding. The Constitution does not. The Constitution puts the structure and the limits on government. Okay, this is the Article 1, Section 4 is a limitation of the federal government, and establishing that that's the state's job. That's a job of the state legislature. A fundamental disagreement is that the Constitution doesn't give you rights. You're born with them. Okay, individuals are born with them. This is an outline of a structure. This is how it's done. They decide. Let me hear her out.
Giving just anybody in the state that right. They're giving somebody called the legislature. And in order for us to have a thing called the legislature, we have to look at the state constitution to determine where those, what that entity's powers are, how they can be exercised. Other than that, I don't really understand how the legislature is authorized to act at all.
Well, Your Honor, we know that's not right because in Lesser, the people of Maryland tried to prevent women from voting. And the way they did that is they put in their state constitution a prohibition on adopting the 19th Amendment.
And you know what? Let me tell you, I'm going to be honest. I'm just going to be honest about this. Ketanji Brown Jackson, whatever. She got me questioning the whole giving the women rights to vote. That she straight up got me questioning it.
And then it came to this court, and this
what have we done? Good Lord, what have we done?
court said that this is a federal function and that substantive limit of the state constitution was inapplicable.
All right. So okay, let's just rewind that a little bit. Okay. She's saying, why can't states just do whatever they want? And he's explaining to her,
why do we have to follow the Constitution?
Federal baselines that you cannot fall below.
Right. If you're surprised that a Democrat who can't define what a woman is posing honestly, genuinely the question of why state constitutions, right, have to adhere to the national constitutions. If you're wondering why she's asking that question, you probably just woke up from a coma, and I want to apologize for the state of the world.
below, right? There are
Because
constitutional
this shouldn't surprise you at all that they have zero respect and they feign a lack of understanding of the national constitution. They feign. I mean, she's stupid, but she isn't that stupid. I mean, maybe she is. Again, really questioning the 19th Amendment right now.
standards that you cannot below. The example is women's suffrage. Okay, there was a law says women can vote. Guess what? A state said no, they can't. Federal government, right? Let's listen to him explain it better than me.
To act at all.
Well, Your Honor, we know that's not right because in Lesser, the people of Maryland tried to prevent women from voting. And the way they did that is they put in their state constitution a prohibition on adopting the 19th Amendment. And then it came
Can't
to
do
this
that.
court, and this court said that this is a federal function and that substantive limit of the state constitution was inapplicable.
Right.
So that's what we're dealing with here is a federal function.
But that was because it
And Ketanji just learned about federal functions. Now, Sotomayor is going to jump in here, and the rest of this clip, they get a little bit combative. It's a pretty fun exchange here, and let's check in.
So that's what we're dealing with here is a federal function.
But that was because it violated the federal constitution, not because it violated the state constitution.
Duh.
But let me go back to what I don't
Doesn't let him answer that.
fundamentally understand about this case.
I would have liked an answer on that one.
The text of the
That's
Constitution of the
it's a
election.
simple acknowledgement of yes. I'm glad we're on the same page. We're here because of a federal constitutional violation of the national constitution. You said it.
Clause says,
I'm
the
glad we see what's
legislature
happening
in
here.
each state shall prescribe the time, place, and manner of elections.
Yeah, we read it.
Yeah.
We know that before the founding, at the
She just caught
founding
up.
of the Constitution, decades after, and even to today, that state constitutions have regulated time, place, and manner. We have the voice votes. We have one constitution that set elections at the courthouse and not in the county where the legislature wanted it. We have laws about voice votes as opposed to ballot votes. It seems to me that if I'm a textualist and I read that the legislature in each state shall prescribe the time, place, and manner of elections, that your argument would have to be that you can't regulate, the state constitution can't regulate that. But there is no substantive limitation in the Constitution. And the 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively. or to the
Objection,
people.
compound question.
And if there's no substantive limitation in the elections clause,
She's filibustering.
I don't know how we could read one in.
Your Honor, so I think there are a few points
It's a
there.
reserved power to the states
Yeah, a
to
lot
decide
to respond to there.
whether apportionment or malapportionment should be prohibited. We've already had a case grow
Bro,
by
he
Justice
said she's
Scalia, who
filibustering.
said
Bro,
that was perfectly
mind
okay for a
wrapping it
state
up?
constitution
who
to
fucking nominated
prohibit
her?
malapportionment. Under your theory,
They should be slapped.
the state constitution shouldn't have been permitted to do that substantive thing. So explain it to me.
Yes, so let me start with where Your Honor started, which was with the history. And we read the history very differently than my friends on the other side because they point to 16
Not surprising.
constitutions
Okay.
early in the founding of the Republic that they claim regulate federal elections. 5 of those relate to transitional
I can't
governments.
stand on
There was
this.
no state legislature. So it would have been impossible for the state legislature to adopt the first rules. And by their own terms, they were schedules that faded away once the state legislature had been elected.
Okay, so the government is now trying to rely on something called legislative history or really constitutional history, right? It's not even like legislative history. It's like United States history. What is the Constitution that was before the U.S. Constitution? What was one before that one? What was the one before that one? They don't like that the current
The
Constitution,
Magna
the one that
Carta
we
says
cherish
nothing
and
about
revere,
state
is
legislatures.
referencing this section that says legislature. So they go, okay, well, we don't know how to define that word. he says it's pretty clear. It's the Congress. The other side, the government, says we're not real sure what it means. So let's go find a bunch of other garbage. They go and they find 16 others of these things. And they say, well, there, it legislature sort of did mean the governor, or it sort of did mean the courts, especially for elections. And he's saying, yeah, but those are all irrelevant. Those were transitionary governments. Those were like different, territories that were then working their way up through a new land and then working itself up into the United States.
I don't remember.
colonies
I don't
into the
remember
United
that shit
States.
being ratified
So
by
it's
the state
totally
of
irrelevant.
Texas.
Now,
Right.
Sotomayor doesn't
Exactly.
like that history lesson that he is giving to her, and listen to her interject again.
Then that leaves 9, which say that have regulations relating
There
to,
were only 13.
well, I'm giving
There
them
were
credit.
13 colonies, Counselor. If I got
Counselor.
6 of them doing something that's contrary to what you're saying, that seems like a fairly substantial majority to me.
Well, Your Honor, I'm going to get.
You can try to knock them down one at a time, but you still, with about 6 of them.
Okay. This Democrat math right here. You got 13 colonies, Counselor, right? And if 6 of them, colonies, transitional governments. Okay. 6 is not a significant majority of 13. But again, if you're surprised that we disagree on what a majority number looks like, I don't know what to say. That's that Democrat math. These are fundamental disagreements we have. I'm not sure that we'll ever get on the same page about these
that
types of
can't be
things.
disputed.
I'm going to
Going through all of the different colonies now and saying, oh, well, they did it this way and they did it that way. And so he's saying we should do it this way because there are more of them that did it this way than that way. In other words, some state legislatures were defined as the state legislatures and others were not. So they're going through the numbers one by one.
Which is all really funny because I don't remember any of the constitutions from any of the colonies or whatever structures of government they had being ratified by the state of Texas. Oh, I'm sorry. Maybe I missed when that shit was ratified recently. Can we? All right. Don't want to play games. I'm about to pull out the Magna Carta. And if it doesn't say shit about state legislatures setting the time, places, and manners of the election, I guess we have no
knock them
case.
all down with honor. I'm going to get regulations relating
There
to,
were only 13.
well, I'm giving
There
them
were
credit.
13 colonies, Counselor. If I got 6 of them doing something that's contrary to what you're saying, that seems like a fairly substantial majority to
I
me.
bet it
Well,
does,
Your Honor,
Democrat.
I'm going to get.
You can try
It
to
does.
knock them down one at a time, but you still, with about 6 of them, that can't be disputed.
I'm going to knock them all down with 1. So it'll be 12-1 in my favor by the time I'm done, Your Honor.
Yes, if you rewrite history, it's very easy to do.
I'm not rewriting history, Your Honor. What we're saying is that when it says all elections,
Nah, he's gonna knock them all down. It's like getting 12 birds stoned at once. And the projection, just the sheer projection. Like, I'm sorry, who's rewriting history right now? Are we trying to determine what the meaning of legislature is? No. No. Clever.
it's referring to the offices that were created by that Constitution. You can see that in Vermont. It says all freeholders shall be eligible for office. It's not talking about the presidency of the United States because there's an age qualification. It's talking about
So why is it that in all of those states, the legislatures understood that all elections meant that you were going to have paper elections, ballots in both federal and congressional?
I think it is telling what those state legislatures understood. And if we look at Pennsylvania and Tennessee, they took those all elections shall be by ballot, and they promulgated 2 statutes to implement that, to implement and regulate their elections laws. For the state ones, they passed a law saying all elections shall be by ballot. For the state,
Okay, see, because the statutes have to adhere to the state constitutions, which has to itself adhere to the national constitution. Okay, that's just how it works. Okay.
races, and they cited back to
Sotomayor.
those state constitutional provisions. And then they passed a separate law for the federal elections, and they did not cite back to that provision. Why not? Because presumably they understood that they were not bound by that, but they were simply trying to harmonize.
That is a large step, Counselor.
That's a large step, Counselor. She doesn't like it at
It's
all.
not that
And
large
here's
of a
the
step.
exchange one more time about history. That's a fun one.
Worried
You don't hear often back and forth like that in oral arguments. Sometimes you do, but this was a good one.
about what you're saying. That seems like a fairly substantial majority to me.
Well, Your Honor, I'm
Fairly. There's another one too, right? So JC, the Music Man, did the math on that. 6 divided by 13, it's 46%. Yeah, so not really a substantial majority there, Judge.
Hey,
own terms.
winner, winner,
There were
chicken dinner.
schedules that faded away, which say
There were
credit.
13 colonies, Counselor. If I got 6 of them doing something that's contrary to what you're saying, that seems like a fairly substantial majority to me.
Well,
Nope.
Your Honor, I'm going to get.
You can try to knock them down one at a time, but
Just
you're
disagree
still
on
with
that, I
about
guess.
6 of them that can't be disputed.
I'm going to knock them all down with one. So it'll be 12-1 in my favor by the time I'm done, Your Honor.
Yes, if you rewrite history, it's very easy to do.
I'm not rewriting history, Your Honor. What we're saying is
Petty.
that when it says all elections, it's referring to the offices
Gee,
that were
project
created
much?
by that Constitution. You can see that in Vermont.
All the offices created by the Constitution, right? And it's very, very fun debate. So we'll see what the U.S. Supreme Court does. Of course, when the ruling comes down, we'll cover it, I'm sure.
Right, because and that's about the end of that video. If y'all would please sub to this Robert Gouvet Esquire, he's really great. Here's his channel. Here's who he is right here. If you'll sub to him, he's really great. But yeah, so this, sure, the state constitution can create offices, right? They can say, okay, this, but it has to be within the 3 branches of government. For the most part, that's just what we do. I think that it's a strong argument that state constitutions cannot oppose or violate the national constitution, which kind of lays things out. It's a debate worth having, though, because clearly, right, this is being exploited. This particular aspect of our little experiment, right, in democracy, our Republican form of government, is being exploited. So this is definitely a debate worth having, all right, and it's worthwhile to spend your time mocking and laughing at them. They are mocking and laughing at us. The difference is we have the Constitution on our side. They've got to redefine words and jump back to documents that are not currently on the books to be able to justify the positions that they're taking. They are not standing on constitutional ground. We are, okay? So get you a copy of this, read it, understand it. I'll share more information about this case. It's very, very important. These arguments are going to be the basis for most of our legal cases moving forward. Where you're finding issues that are inherently violations of state statute, state constitutions, federal law, and the national constitution. That's bad. That's real bad. That's not good. Okay. So thank you for watching. I hope you enjoyed it. I'm going to be updating my other social media sites. I'm going to be updating them with stuff like this. It'll just be links to the stuff that I do, and I will be posting my glossary of terms soon. I forgot to finish that, but I'll be posting it soon. It's taken a lot to work on. Anywho, thank you guys. Y'all have a good night. Bye.